President Reagan today signed a 25-year extension of the 1965 Voting Rights Act. The president, who originally favored only a 10-year extension and came late to endorse this version, had nothing but praise for it today.
The right to vote is the crown jewel of American liberties, and we will not see its luster diminished.
The bill signing ceremony, moved indoors because of the threat of rain, was witnessed by some of the president's severest critics, black civil rights leaders and Democratic Senator Edward Kennedy.
In April of 1982, President Ronald Reagan signed the third extension of the 1965 Voting Rights Act. And he signed it reluctantly, because this 25-year extension included an amendment to Section 2 of the Voting Rights Act, the VRA, which prohibits discriminatory voting practices. And the Reagan administration really did not want to sign that. The amendment ensured that victims of discriminatory voting laws would not have to prove that the laws were intentionally designed to be discriminatory. They just had to prove that they were discriminated against, that that was the effect of the law. Now, this issue had been litigated for years, even in the Supreme Court, which ruled in 1980 that, with exceptions, the VRA only forbade intentional discrimination. After that 1980 ruling, James Blacksher, an attorney for the black voters in question, called the decision the biggest step backwards in civil rights to come from the Nixon court. That is why the amendment Reagan signed in the summer of 1982 was so important. It kept the country from taking a giant step backwards. That is why civil rights advocates lobbied so hard in favor of it, and it is why, presumably, the Reagan administration lobbied equally hard against it, with the help of a young lawyer named John Roberts. For months before Reagan signed that bill, Roberts, then a special assistant to the Attorney General, drafted a series of memos detailing why no amendment should be added to Section 2 of the VRA. He argued Section 2 should be kept the way it was, prohibiting only intentional discrimination and not just discrimination. Roberts argued that violations of the Voting Rights Act should not be made too easy to prove, since they provide a basis for the most intrusive interference imaginable by federal courts into state and local processes. Roberts added that revising parts of the VRA would not only be constitutionally suspect, but also contrary to the most fundamental tenets of the legislative process on which the laws of this country are based. Well, John Roberts lost that argument in 1982. Congress passed it, and President Reagan signed the updated Voting Rights Act. But that was just the beginning of John Roberts' work against the VRA. As a Supreme Court Chief Justice, Roberts would get more opportunities to gut the law, starting with Section 5 of the VRA, which was designed to monitor states with a history of racial discrimination.
The court's conservatives today followed through on a threat they made 4 years ago to strike at the heart of the Voting Rights Act unless Congress updated it. The ruling deals a crippling and potentially fatal blow to the law signed by President Johnson in 1965, a response to widespread efforts in the South to prevent blacks from voting.
And very soon, the Supreme Court could have another chance to erode voting rights protections. On Monday, a federal appeals court panel ruled that Section 2 of the VRA does not allow private plaintiffs to bring lawsuits. Contrary to the way the law has worked up until now, this appeals court now says only the federal government can bring lawsuits alleging violations of the Voting Rights Act. The case is almost certain to reach the Supreme Court, and when it does, Justice Roberts and the other conservatives on the court could continue the campaign to hollow out one of the most important anti-discrimination laws in this country. The Atlantic's Adam Serwer is calling this the decision that could end voting rights. The Constitution is supposed to forbid such discrimination, but that sounds simpler than it is. In practice, if you have enough judges or justices willing to find unconstitutional the laws adopted to enforce that right, or willing to rule in such a way that nullifies the ability of those laws to function, you can simply render the 15th Amendment, the one granting black men the right to vote, you can render that useless. Joining me now is Adam Serwer, staff writer at The Atlantic. Adam, thanks for being here tonight. Your piece is so essential in this moment. You draw a sort of through line between the justices of the Supreme Court in the what you call the twilight of Reconstruction around 1871 and today. I wonder if you could elaborate on that for folks who haven't yet read the piece.
Well, I mean, the 15th Amendment was adopted during Reconstruction. And what happened was that it simply ceased to be enforced. The Supreme Court of that time simply allowed it to be nullified by the southern states, which wanted to impose a Jim Crow regime on Black people in the South. And it required a second Reconstruction to make the rights guaranteed by the 15th Amendment real rights. And what happened in the decades following is that people like John Roberts decided that racism was over, that racial discrimination in voting was not a serious problem anymore, and that the bigger problem was, as he put it as a young attorney in the Justice Department, this interference with the rights of the states to limit voting as they see fit, even if that abridged the rights of Black people to vote. And that really is the problem here. And the question is whether he still has that sort of dorm room libertarian naivete, even now, after Alabama openly defied a Supreme Court ruling in this past year because they wanted to dilute the votes of Black citizens of Alabama. The question is whether he and Justice Brett Kavanaugh, who told Alabama that to follow the Supreme Court's ruling and draw a second Black district in Alabama where Black voters were able to elect the representative of their choice. The question is whether they are committed to this idea of unraveling these laws that protect the right to vote, whether it's a question of ideology or naivete, whether they've been shown just how serious this problem continues to be, and therefore understand now why these protections were adopted in the first place, or whether they're so bent on helping the Republican Party disenfranchise their constituents that they'll allow this to go forward.
Adam, to that end, I mean, you assign, I would say, not the best of motives in terms of the Supreme Court's ruling on that Alabama case, Allen v. Milligan. Can you talk a little bit about how you understand the court to have ruled and why you think they voted effectively in support of Black voters in that case?
Well, there's two cases that we're talking about here, right? There's the initial case in which they upheld the Section 2 challenge that, Alabama was required to draw a second Black district because, a large portion of the state's population is Black and they only have one majority Black district. But the real issue, I'm not, in terms of motive, I mean, it's actually quite interesting that Kavanaugh and Roberts upheld the law in that case. But the second time around, Alabama basically assumed, the court is majority Republican appointees, so we're going to do what they want, and they're going to let us do it. And what the court said was, well, no, we're going to uphold the law because to allow you to simply openly defy a ruling like that would undermine our power as Supreme Court justices. If you say that the Supreme Court what the Supreme Court rulings are the law of the land, and you allow people to defy those rulings, it's not just going to be Alabama defying it. It's going to be other actors who don't like the outcome of certain cases. So in that case, the decision, I believe, was unanimous in terms of telling Alabama the second time to go back and draw that district. But that was a direct challenge to the power of the Supreme Court.
Yeah.
And this case is a statutory case. It's not a direct threat to their power. And so they can rule safely without undermining their own authority.
It's about the power of the court and not necessarily enfranchising Black voters. Adam Serwer, thank you so much for your time.